Welcome to American Dreams, Keys to Success, with your host, Arlen Olsen.
Welcome to American Dreams right here on AM 1220 KDOW. We got a great show coming up today. The first segment, we're going to be having Arlen Olsen. He's a patent attorney. We're going to talk about patent law and, why you should be thinking about patenting your products if you're in a startup company or if you're an inventor. The second segment we'll devote to corporate governance. We have an attorney with Ramon Law Group coming on, Douglas Park. He teaches strategy at Stanford University, and Dr. Park is a Harvard law graduate and devotes his time in helping companies with their corporate governance and strategies. So with that, Arlen Olsen, welcome to today's show.
Thank you, Alan.
Now, you're a patent attorney, and tell me exactly at what point in time should somebody come and seek you out?
The best time to do it is before you've disclosed your idea or your invention to third parties. Right now, we're in a hurry up type situation for patenting inventions. On March 16th, the AIA, or American Inventors Act, passed, which converted us to a first-to-file type system. So it's important to get to the patent attorney right away. You may have a great idea, but there may be somebody else out there that already has that idea, that has it patented, and you may be stepping on other people's territory. Going to a patent attorney early on also helps with your investment capital. Getting a patent portfolio set up helps you attract investors. We just recently had a multi-million-dollar injection of capital based upon a patent portfolio that we issued.
Now, if you have a patent in process, at what point in time does the patent belong to you?
Well, the patent belongs to you as soon as you file it. You can file an assignment on a pending patent, but you can't actually go out and enforce it. It's not a property right granted to you by the government until the patent actually issues. So you do not have an enforceable document until that point in time.
So what does it take to get an enforceable document? Walk me through the process for a patent. I've heard a lot of people and entrepreneurs in Silicon Valley saying, the technology changes so quickly, why bother getting a patent? Because 18 months down the road, this technology will be useless.
Right. Well, the process is the first step you would take is you would do a patent search to determine whether or not somebody else out there has had or patented the invention. The second step is once you come up with a patentability opinion by your attorney, he's done his search, then you would actually prepare a patent application. There's a couple ways that you can do it. First is you could file a provisional application, which is a really quick and dirty way to get your patent on record with the patent office. This is becoming more popular these days because of the first-to-file rules. You want to get your patent in very, very quickly. And when you file your provisional, then the next step is to file what's called a non-provisional patent. You have a year to file your non-provisional. If you sit back and wait and you just let the technology move ahead of you, you could be in a situation where somebody else files the technology first, the patent first, and then you're in an infringement suit. So at the very least, you should get a provisional patent or some patent on file with the patent office to put your marker in place that stakes your claim in the ground that this is my property right.
How do you advise clients, the entrepreneurs, once you get a patent, what's the next step?
Once you get a patent, the next step would be to, it depends on where you're at and what type of business model you have. If you're trying to seek investment capital, you would use your patent in your business plan to seek your investment capital. You could use your patent as a defensive measure so that it would block other people from entering into your patent landscape. Or you could use your patent offensively to go after other people, to stop other people from infringing your technology.
There was something in the past called patent trolls. Do they still exist today?
Oh, yes. They're very live today.
And what is a patent troll?
The first patent troll that I'm aware of is a guy named Jerome Lemelson. He filed his patents back in the 1950s. And he never actually practiced his patent. A troll doesn't practice their invention. They just use a patent to go out and sue other people and to get licensing value out of it. So the laws have changed drastically since the 1950s when Mr. Lemuelson got his first patent. He made millions and millions off of it. He came up with ideas such as optical scanning in robotic production. He came up with ideas in Velcro. He had ideas in just a wide variety of things, early semiconductor processing. And he would get these patents and go after companies and sue them. And then about 10, 15 years, it became very popular for companies to go out and buy up patent portfolios and sue infringers. And this became very difficult on the venture capitalists. People that were investing in startups, it became very tentative. You have cases like the RIM case, the BlackBerry case, that were sued for hundreds of millions of dollars. And right now, with the new laws coming down, they're changing that. They're trying to get away from patent trolls being able to take advantage of the system. In a lot of foreign countries, they require inventors to actually work their patents before they can gain benefit off of it.
Yeah, it's interesting you brought foreign countries up, because if I have a patent in the U.S., is it enforceable in another country?
No.
And so how do you help to protect that technology for your clients that you just got a U.S. patent issued? How do you enforce a patent internationally?
Well, I think the best step is, if you don't know what your foreign markets are, is to file what's called a PCT application, Patent Cooperation Treaty application. And that gives you a time delay between 30 to 31 months before you have to file your foreign patents. It's really not an enforceable document, but it gives you the time that it takes to see if your markets are viable in foreign countries. Most developed companies actually know where their markets are, and they have a list of foreign countries that they want to file in. So they can go in directly. But for a startup, I'd recommend filing a PCT application.
And where does the PCT application go to?
It's actually administered by a section of the United Nations called the World Intellectual Property Organization, and that's out of Switzerland. But they also have receiving offices throughout the world. So you could file in any receiving office in the world. For example, the U.S. has one, Europe has one, Japan has one, Korea has one, China. And if you want to get your search done in a foreign country, you can also designate a search. So if your technology is really hot in Europe or Japan, you may want to designate those as your countries to do their search. But the actual place that the PCT is received depends on where you file it in your receiving office. Typically in the U.S., you would file it in the U.S. receiving office.
All the patents still are issued by the same agency in the U.S. And the patent office is out of Washington, D.C.?
Correct.
So, if I wanted to expedite a patent, is there a process to do that?
Yes. There are certain rules that govern the expedition of patents. For example, last year, we had a company that was a startup that needed to get their patents issued very quickly to get venture capital in, and they were a green tech company. And there are petitions that you can file to expedite patents if it has an environmental value to the country. And so we're able to issue these patents very quickly. If you're an older inventor, 65 years or older, you can get your patent through quicker. If you have health issues, you can get the patent through quicker. If the patent's potentially in litigation, there's ways to get it through quicker. A lot of different ways that you can get your patent through quicker, and you should be aware of this, especially if you're a startup and you need to get patent protection quicker. The average patent takes about 18 months before it issues.
Arlen, I understand you used to be a patent attorney also.
Yes.
What was it like working on the other side?
It's actually fascinating, but you don't actually get to be hands-on with the real invention. You don't get to actually see it. You just have a piece of paper coming in, but you get to see a lot of different inventions coming through quickly. When you're an examiner, you're assigned to a specific area or technology, and I worked in things dealing with earth and hydraulic engineering. So I would do these wave pools that they do in amusement parks, scuba diving equipment, tunneling machines, snow removal equipment, a lot of different areas, but you're specialized in an area. And you get to meet a lot of really neat people as an examiner.
I understand you also are a collector of unusual patents.
Yes.
Can we talk about that?
There are quite a few funny patents out there. There's a patent on a method for walking a snake with a stick. There's also ones that are kind of crazy. There's a device out there that you would put onto a carburetor that would save gas based upon the phases of a moon. Now, the patent office found out about this particular invention, and they went through and did what's called a re-examination and invalidated the entire patent because it just didn't work on basic scientific principles. In Japan, they have patents on making square watermelons and also making a baby suit that has a mop head attached to it. So that as the baby crawls across the floor, it actually mops up your floor and cleans your floor. It's a dual-purpose invention, great for young mothers that don't want to clean the floor, and yet their kids get around a lot. So it's a great idea.
When are we going to see that in the U.S.?
You may be able to get it now. I'm not sure if it's on the market or not. They also have crazy inventions on toasters that will make the face of Winnie the Pooh on your toast when you burn the toast. There's a rock, paper, scissors card game that you can get. And then there's just very unusual, out of the ordinary, crazy inventions on like a greenhouse helmet where you would run with the helmet over your head that has little cactus plants inside of it that create oxygen so you can breathe better.
Oh, man. Well, Arlen, how does a person contact you?
My website is www.iplawusa.com, and my phone number is 518-220-1850.
It's Arlen Olsen, patent attorney with Schmeiser Olsen Watts. Arlen, appreciate you being on today's show.
Thank you very much.
We'll be right back after these messages.
You're listening to American Dreams with Arlen Olsen on AM 1220 KDOW.